Hi everyone, welcome back to SAFAVI Legal channel. I know I have taken a long time for uploading the videos. I apologize for that. I'll try to make consistency and thanks for your patience. We have covered previously various topics. It's relating to civil law, criminal law, DPC, land laws, and along with that torts as well. In the torts, we have covered vicarious liability, absolute and strict liability, but we have not covered with the various general defenses. General defenses are very important, as well as in the tort or in the criminal law also. In that, today we will try to cover the volenti non fit injuria. Okay. So before going to start the defense, that is a volenti non fit injuria, we will recall with the definition of tort. Tort, it is nothing but it is a civil wrong, and it is comes from the Latin term tortum. Tortum, it is a Latin term which is nothing but twisted or crooked act, or it is also called the civil wrong, and it is exclusively breach of contract and the breach of trust. Means it is not neither a breach of contract nor the breach of trust or other type of civil wrongs. Why? Because the Salmon defined, according to the definition of the Salmon said tort is a civil wrong for which the remedy is a common law of action for unliquidated damages, and which is not exclusive to the breach of contract or the breach of trust or other merely equitable obligation. So here clearly discuss about why it is not a other type of civil wrongs. So that clearly discuss about the unliquidated damages. What is that liquidated damages? What is unliquidated damages? When we take about to the breach of contract, it is a liquidated damages. Suppose if A file a case against to the B for certain amount, liquidated is nothing but what? Certain amount. Means suppose if the A for 50,000 file a case against to the defendant, that is the B, then the court also will award the 50,000 rupees only, not more than that. Whatever the person, the aggrieved party file in the court will also award the same kind of compensation. That's why such type of compensation or the damages are called the liquidated damages. Whereas in the law of tort, it is not the liquidated damage, it is the unliquidated damage. It depends upon the discretion of the court. Might be whatever the amount filed by the plaintiff, as it is also they can file, or any other, might be the less or to the increasing that amount. So it depends upon to the discretion of the court. That's why it is called that whatever the damages are called the unliquidated damages. So that's why it is exclusive to the breach of contract or the breach of trust. Okay, now we can go with the defenses, because we know that here in every case two parties are there, that is the plaintiff and the defendant. Plaintiff, the plaintiff has to show that aggrieved party, we can also call the aggrieved party, he has to show the various evidences. That's why it's said about the burden of proof. Whereas other party is called the defendant, benefit of doubt. So whatever that allegation made by the plaintiff, he has to show the various evidences, that is the benefit of doubt he has to create it by the defendant. So these are the various general defenses which is supporting to the defendant, which is helping to the defendant. What are those? That is the volenti non fit injuria. Volenti for non fit injuria, generally I'll just go with the one line explanation. Later on I'll try to go with various case laws also. It is nothing but consent of the plaintiff. It is nothing but consent of the plaintiff. Suppose the plaintiff has given the consent, then that how the defendant is liable, how the defendant is responsible. So that's why it is a good defense for the defendant. Whereas the other defense, it is called the plaintiff the wrongdoer. Plaintiff only committed, the plaintiff only, suppose the plaintiff committed any unlawful act, the plaintiff's committed any wrongdoer, plaintiff only the wrongdoer, then how he will be liable, how the defendant will be liable. So if the plaintiff's fault is there, then he is not a right to file a case against, even the court is also take any action against to the defendant. So this is also one of the good defense for the defendant. Other thing, it is the other defense, it is relating to the inevitable accident. Inevitable accident is nothing but it is unforeseeable or unavoidable events or the accident. So after taking care and caution also, if unavoidable those type of accident, then also the defendant is not responsible about that particular action or the injuries. So this is also one of the good defense for the defendant. And the other one, it is the act of God. We know that natural calamities completely depends upon the God will give. So natural calamities, if suppose any damages happen, might be that it's one of the defendant is also one of the person, but that completely happened by the act of the God. natural calamities, then the defendant is not responsible of any of the damages. Any of the damage happened, any of the injuries happened, but might be from that defendant only, then he will not be liable. It is also one of the good defense for the defendant. Other thing is the private defense is also one of the good defense. Not only here in the law of tort, it is a good defense in the criminal law also. So self-protection. Self-protection is a very important in the criminal law, very because recent scenarios we know that we are seeing the various incidents. So self-defense, self-protection, not only the self-protection to the body, self-protection to the body, self-protection to the property. Okay, so self-protection to others' body, self-protection to others' property. It is a defense to that property, defense to the person. So this is also one of the defense, but here some limitations are there. When we'll go with that explanation of the private defense, we will try to discuss about the various limitations also. Now another defense, it is about to the mistake. Mistakes in the sense it should be a bona fide. It's a bona fide error. Means after discussion of various things also, if any error happened, it should be a bona fide. It's a fact, whatever the mistake of fact is excusable, but mistake of his law is not excusable. That one we have studied already in the criminal law. So that one should be a bona fide error. Okay, so it should be one of the good defense in the law of tort. Next one, it is the necessity. Necessity, wherever the necessity is there for the property, for protecting of somebody's property, for protecting to somebody's life, the person knows about it, it's damage or harm to the life of somebody's life or somebody's property, then wherever the necessity is there, then they can take an action. They can do some of a lawful act. So that is also one of the good defense for the defendant. And the next one, it is the statutory authority. Statutory authority, we know the statute, legal authority. Legal authority, various legal authorities, we know that, like suppose constructions, barrage constructions, railway station constructions, or whatever it may be, they have occupied the various land. Nowadays we know that we are going to listen that is about to the Hydra. So it is their authority, they will do that work. Okay, we don't have a right and file a case against to those people. Might be some property injury will be happened, then we don't have a right to file a case. Yes, we have other liabilities are there, like public interest litigation or any writs are there, but according to the civil law, we can't take against to the any statutory authority. So the statutory authority is also one of the good defense in the law of tort. Now we will go with the main thing, the topic, it is relating to the volenti non fit injuria. Volenti non fit injuria in the sense what? Voluntarily consent given. If suppose a person voluntarily given the consent, any injury will be happened, then the person will not be liable. So to a willing person, no injury is done. If a person willingly consents to the infliction of a harm upon themselves, they are not entitled to any remedy under the law of torts. Means in the sense what? If any they have given the consent, if any of the injury happened, then they will not be liable. So here consent is various types are there. Whether it may be express consent or implied consent. Express consent, we know that suppose when we are going to hospitals for any surgery or anything else, expressly, directly, we are filling the documents, right? Filling the documents, we have given the consent, express consent we mostly will give the express consent. So this is for suppose anything will be happen without the negligence of either the doctors or the hospital management. If the patient died, then these people will not be liable because the person, the patient or the guardians of the patient, they have given the consent expressly. And some of implied consents also be there. Suppose if you are going to any match, for what you want to watch any match, if you suppose you sit in front row of that match, you are watching that, if anything will be, any injury will be happen, then you will not, those people will not be liable. So those things, express and implied consents also described in the volenti non fit injuria. Okay, now go with that. One of the case law, it is relating to the Padmavati versus Duganika. That is, it's about to that two strangers took a lift in a jeep while the driver was taking it for filling a petrol unexpectedly. One of the bolt fixing the right front wheel came out, resulting in both strangers being thrown out and seriously injured. One of them died as a consequence. This is in the sense what? a persons, whoever the strangers were they, who lifted that jeep, they wantedly consent they have given. If might be any accident happened, how the driver will be liable? No, the master also, the driver and or the master will not be liable as per this case, as per that volenti non fit injuria. Now we can go with that. What are the essential elements of the volenti non fit injuria? Here are the various essential elements given. That is the free consent, no fraud, no compulsion, no negligence, or not a mere knowledge. So various definitions, the various essential elements given. Free consent. So consent, previously I said volenti non fit injuria, it is nothing but it is not a person who has given the consent. Okay, that consent might be expressly or impliedly. Whatever that consent, if suppose if they give any injury happened, then this person had no right to file a case against to those things. Okay, so these things which has been described, the definition part of the volenti non fit injuria. Now suppose when we see about the various limitations or the essential element, first thing is the free consent. That consent must be free, not taken fraudulently, not taken forcibly. Even these consent, suppose a person given by a minor, not acceptable. If suppose a person given by the unsound mind person, not acceptable. At the same time, if a person any forcibly, fraudulently, or for some any property or anything else, if they have taken the consent, or intoxication situation, if they taken the consent, that one is also not acceptable. Then the defense will not be applicable for these type of essential things. Now we go with that fraud. So fraud is there, compulsion is there. Any compulsion, forcibly the people are joined in that, they have taken the consent, then also this defense will not be applicable. No negligence. Negligence is, suppose I have given one of the example, it is about to the doctors. Suppose a person has given the consent expressly only, they fill all the forms and documents, but negligence happened by the doctors or any of the hospital management, then this defense will not be liable. Definitely that management or the doctors will be held liable. This volenti non fit injuria not applicable to these management because of the negligence happened. The defendant must not be negligence. Negligence avoids the applicability of the doctrine. And other mere knowledge. Suppose some people have the knowledge about, mere knowledge is there, but they need it, the necessity is there. So for the necessity, at that time also, these things will not be, this defense will not be applicable. Okay, now go with that free consent and consent without fraud. Free consent, so it should be free consent, but one of the beautiful cases, two very landmark cases are there. It is about the compulsion, mistaken impression, that is the Lakshmi Rajan versus Malar Hospital Limited. In that the case, the patient consented to surgery for a breast lump, but her uterus was removed without justification. The court rejected the voluntary non-fit injuria defense. Consents for one procedure does not extend to the another. In the sense what here? Negligence happened. In this case, actually they want for that removal of the lump in the breast, but they removed the uterus. It is what? Negligence happened. Okay. Free consent given. Might be the consent given expressly only, but negligence happened in the sense this defense will not be applicable. And some fraud, consent taken with the fraud. What is that? Here this is also one of the landmark case, that is R versus William. Here a music teacher had a sexual intercourse with a 16 years old student by making her believe it would be improve her voice. The court held that accused guilty of the rape. The volenti non fit injuria not allowed as the consent was obtained by the fraud. So here beautiful case law, it is a very landmark case law. In that clearly describe about that means that the person who said to that minor girl, if suppose they committed, if suppose they have do this act, that the voice improved. This is what? Fraudulently taken the consent from the minor. So here it comes under the whatever the offense committed, whatever the unlawful act committed by the person, just comes under the rape and he had held liable. and this volenti non fit injuria not applicable. So these are the various important case laws described, and some are not supported because somebody taken consent fraudulently or not given freely or taken by the minor or taken the consent from the any insane person, intoxicated person. So these defense will not be liable, they will not be applicable. Okay, next one is the master servant relationship. Consent must be obtained under compulsion. So suppose if they have taken with the compulsion, so servants generally we know that with the dilemma of either accepting of risky tasks or the losing their jobs. So if servant agrees to undertake a risky job, it does not necessary to imply that they also agree to suffer the consequences of that risky job. So we know that if suppose if they accepted, if they might be joining into that any of the job, as an employer, he has to take more precautions to the employee, right? Might be for the job they need it, but if it is any risky things are there, master's responsibility to protect the servant. So that is the master servant relationship also mentioned in this volenti non fit injuria. Along with that, one of the important case law which has been given, that is the imperial chemical industry case. It was held that if a workman adopts a risky method of work not because of any compulsion of the employer but of his own will, then the defense of volenti non fit injuria can be successfully pleaded by the defense. So here, without any compulsion, the person who enter into the job, sometimes we know that some risky are there. If suppose they have given very it is dangerous things, in the sense the employer's duty, master's duty to take a responsibility of a servant. Okay, but in various cases we know that some dangerous things are, but still they will be enter into those jobs. But then that this defense they can plead for the defense successfully. Okay, now we can go with that defense of must not be negligent. So whatever that thing, it should be a careful act. The precautions has to be taken. If suppose that any negligency happened, then according to whatever the negligence happened, whatever the offense or lawful act committed, they will be liable. Then this volenti non fit injuria will not be applicable. So various cases, the principles the some of the cases given, we know that the Sridevi case is also very famous case, left brain injury to right brain surgery done. So this is also one of the cases relating to the negligence case, that the lots of amount compensated by the US government. So these things happen here, that but they cannot use to that volenti non fit injuria. In that also various other important landmark cases are the Smith versus Baker case. Some dangerous things, in the sense the master should be responsible. Some dangerous things should, if they are doing with the dangerous things, in the sense master should be responsible. That might be the servant have a knowledge about that, but still that the masters is responsible, then they cannot use to that volenti non fit injuria. So in that situation volenti non fit injuria will not be applicable. Okay, so this is about to the various cases. Smith and Baker cases also very important in the landmark case in the volenti non fit injuria. We have various other cases also there. Now, okay, now with the other defenses like plaintiff the wrongdoer, inevitable accident, or other defenses we'll try to discuss in the next class. Thank you. Thanks a lot for watching my channel.